In the landscape of American governance, the question of who controls the executive branch has long been both foundational and contested. For most people, the issue seems settled. The president is the head of the executive branch, the person responsible for ensuring that the laws are faithfully executed. But buried beneath that simple idea lies a network of agencies, commissions, and appointed officials, many of whom were intentionally designed to operate with some level of independence from the president who oversees them. It is here, in this gray zone between independence and authority, that the roots of the case known as Trump versus Slaughter take shape. To understand the argument advanced by Donald Trump and his legal team, we must walk slowly and carefully through a constitutional landscape that is more complex than it appears. Their position is not merely a political stance, nor is it framed as a reaction to any particular commissioner. Instead, it is built upon a series of constitutional claims, historical precedents, and structural interpretations of how the executive branch is supposed to function. At the heart of Trump's legal argument is a structural principle. The president cannot effectively lead the executive branch if he cannot control the people who exercise federal power under his name. This idea is not new. It is anchored in the text of Article 2, which assigns executive power to the president alone. The argument begins with a simple premise. If the president is responsible for enforcing the laws, he must be able to remove those who impede that responsibility. This is where the conflict with independent agencies arises. Agencies like the Federal Trade Commission operate with commissioners who are not easily removable. Their decisions, policies, and enforcement actions can continue even when the president disagrees with them. To Trump's legal team, this arrangement creates a constitutional tension. If a commissioner acts in ways that conflict with presidential priorities or interpretations of the law, but cannot be removed except for very specific reasons, then the president's ability to faithfully execute the laws is limited. And limitation of executive authority, they argue, is contrary to the structure of the Constitution. From Trump's perspective, the removal of Commissioner Rebecca Kelly Slaughter was not an act of retaliation or malice. It was instead part of a broader constitutional correction, a necessary step to restore presidential authority that had been gradually eroded over nearly a century. The argument holds that Congress may create agencies, but cannot strip from the president the power to control those executing federal law. In this view, the FTC, though designed to be independent, remains part of the executive branch, and therefore subject to the oversight and ultimate authority of the executive. This framework leads to a deeper question. Can Congress create pockets of executive power that the president cannot touch? Trump's legal argument insists the answer must be no. If commissioners of independent agencies cannot be removed by the president except under narrow, rigid conditions, then they wield power that is insulated from democratic accountability. The president, elected by the people, can be held responsible for the actions of the executive branch. But agency commissioners, protected from removal, are not accountable in the same way. To Trump's lawyers, this disconnect undermines the principles on which the Constitution was built. Supporters of the president's argument point to earlier Supreme Court decisions suggesting that the president's authority over executive officials is broad. They refer to cases like Myers versus United States, which recognize the president's removal power as essential to the functioning of the executive branch. They argue that Humphrey's executor, the 1935 case that restricted removal power for independent commissioners, was an anomaly, a product of its time, decided under conditions that no longer reflect the modern administrative state. There is also a practical component to the argument. A president sets a policy agenda. He appoints leaders to carry out that agenda. But if certain officials are shielded from removal, they may pursue different priorities, enforce laws in ways the administration does not approve of, or resist changes in direction. This tension becomes especially stark when political control of the White House changes. A president may find himself overseeing agencies led by officials appointed years earlier, officials whose views do not align with the goals of the new administration. Trump's legal team emphasizes this as a structural problem. The executive branch cannot move cohesively when its leadership is fragmented across insulated positions. In their view, removal power is not merely about eliminating one commissioner. It is about restoring constitutional clarity. If the president cannot remove an official who executes federal law, then the official is no longer truly part of the executive hierarchy. They become instead a semi-independent actor whose authority rivals that of the president. This, the argument goes, is incompatible with the design of the Constitution. Trump's legal team also challenges the idea that independence is always beneficial. While independence may protect agencies from political influence, it may also prevent them from responding to elected leadership. The argument frames presidential removal power as a safeguard against stagnation and unaccountable bureaucratic control. Ultimately, they say the president must remain the apex of the executive branch, not merely in title, but in practical authority. The firing of Slaughter, when viewed through this lens, becomes a symbolic and constitutional act rather than a personal or partisan one. It is used to illustrate a broader conflict, whether independent agencies can operate beyond presidential oversight, or whether the Constitution requires that all executive power, however distributed, must remain subject to presidential control. Trump's position is that the latter is required, that the Constitution, properly interpreted, leaves no room for removal restrictions that override the president's judgment. Even those who disagree with Trump's legal argument acknowledge that it raises serious constitutional questions. The boundaries between independence and accountability have always been blurry. But by pressing the issue to the Supreme Court, the case forces the nation to confront these questions directly. In doing so, it invites a re-examination of nearly a century of administrative practice. This is only the foundation of the argument, the starting point of a broader and more intricate narrative that continues to unfold. Trump's legal argument draws heavily from the structure of the Constitution itself. In their reading, the document is not merely a list of powers and prohibitions, but an architecture, an arrangement of governing authority that places the president squarely at the top of the executive branch. Every officer who wields executive power, whether high-ranking or obscure, ultimately derives that authority from the president. This idea traces back to the vesting clause of Article 2, which states that the executive power shall be vested in a president of the United States. To Trump's lawyers, this clause is more than symbolic. It is definitive. It means the president must have the ability to direct, supervise, and, when necessary, remove those who carry out federal law. Their argument points out that the Constitution does not mention independent agencies. It does not draw a distinction between those who answer directly to the president and those who do not. The document simply assigns executive power to the president and expects accountability to flow from that single point of authority. If Congress could create officials who exercise executive power without presidential oversight, the argument goes, then the structure established by Article 2 becomes diluted. It becomes possible for executive power to drift away from the president and settle into corners of the government where accountability is weaker and democratic control less direct. In building this argument, Trump's legal team revisits the reasoning in Myers v. United States, a case decided in 1926. In Myers, the Supreme Court recognized the president's removal authority as essential to the proper functioning of the executive branch. The court explained that a president must have the discretion to replace officers who do not share his views or who impede his ability to execute the laws. Though Myers dealt with a postmaster rather than an agency commissioner, the underlying logic forms a foundation for Trump's position. Removal power is inherent in executive power. They contrast this with the decision in Humphrey's Executor, noting that the case was decided during an era of expanding federal intervention in the economy and an evolving understanding of administrative law. Trump's lawyers argue that Humphrey's executor represent a deviation from the Constitution's design, a moment when the court allowed Congress to create a layer of federal leadership insulated from presidential control. They assert that the reasoning in that case has become increasingly difficult to reconcile with more recent decisions that emphasize strong presidential oversight of the executive branch. One of the points raised in Trump's argument is the idea of unity. The executive branch functions best, they claim, when it speaks with one voice. When leadership is fractured, when an agency can act on its own priorities without aligning with the administration, the result is inconsistency. Policies may conflict. Enforcement may vary. The public may struggle to discern who is accountable for what decisions. This fragmentation, according to Trump's legal team, weakens both governance and transparency. A unified executive branch, led clearly and decisively by the president, enhances accountability because the public knows where responsibility lies. From this perspective, independent agencies pose a structural challenge. Commissioners with fixed terms, protected by removal restrictions, can make decisions that persist regardless of the president's views. They can adopt enforcement strategies or regulatory approaches that clash with the administration's priorities. And while independence can provide stability, Trump's argument emphasizes the other side of the equation. Independence may also result in stagnation, resistance to change,